This is the city of Detroit versus Albert Hemmer Hicks Jr. Case number of SP 1442547, counts 1, 2, and 3. SP 1442765-1. Appearance for the record, please. And strike now, wait a minute. SP 1500872-1. Appearance for the record, please.
That one ours?
Yeah.
Elwood S. Berry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks, and no one is to speak on my behalf.
Okay.
I'm my own attorney.
You're your own attorney. You're an attorney registered by the state of Michigan.
You don't practice to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against you.
Okay, you have been practicing law across the bench since we started this. And I'm challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date, or you want the offer in the back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right. Well,
I'm challenging jurisdiction.
Trial date. I'm denying. What is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so
honor your oath of office, please. Honor your oath of office, okay?
Are we going to sit here and debate those positions?
It's not a debate. It's my constitutional right. It's my constitutional right.
You think so? Okay,
I know so. Are you violating my constitutional rights on how you deem them to be?
No, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you going to do today, Mr. Hicks?
Challenge jurisdiction.
And how are you challenging that?
Because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am in this case.
Okay.
And I deny that motion.
Why you deny the motion? Because you don't have.
So Mr. Hicks. You're a grown man. Let's have a few seconds. Wait a minute. Let's have a few second conversation, okay? Now let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No. Don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay. So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so Now, I'm gonna give you two
As
options.
a matter of fact, hold on. Give me a minute. Give me a minute. You
Go
even
ahead.
went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one, wait a minute, you were the one, Mr. Hicks, that said, oh, you can say all that while you're on the bench. Did
Do
you
you have the
say that
transcript?
last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes,
yeah,
I did.
I thought about
You don't
that.
even have a
I
license
thought
to
about
practice
that.
law.
Listen, this
You
whole,
have a license to practice law. Come on, the jig is up. The jig is up.
all right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now, I'm gonna give you two options. The first option is you can either take the deal that's in the file,
I'm not.
or we can, okay, don't talk
Then
while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got
Don't
your
talk.
paperwork ready. I got your paperwork ready. You really
Don't
want to
talk.
You
There
really
you
want
go
to do
again.
this?
All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay. All right. So the other option is we set a jury trial, and we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right to. No, you don't have a right to either or.
Yes, I do. Of course, I do.
All right. I'm moving on.
All right, move on.
You didn't answer my question, so I'm moving on. And I'm going to put you out, or at least mute yourself. All right, let's do this, and let's go back on the record one more time with Mr. Hicks.
Record, Your Honor. Chiku Mason, City of Detroit, 434.
Something's wrong with your volume, Ms. Mason.
Oh, I'm sorry, Your Honor. It might be my mic is down. For the record, Your Honor, Chiku Mason, City of Detroit, 43471. This is the date and time set for a final pretrial in this matter. Your Honor, I did subpoena my officers to be here today for the final pretrial, and I do not see them here today.
Remove your hat, please. No drinking, please. Treat this like you're in the courthouse. Remove your hat, please, Mr. Hicks. All right. What are we going to do? The officers were supposed to be here today. I'm only dealing with SP 144, 2547, no, 12, and 3 SP 144, 27651, and SP 5008721. I'm only dealing with those matters. And the officers are not here. So we're going to make this easy. And now, what I don't appreciate is, I thought about that comment that you made that last time. Basically, you're almost like a little lightweight threat that you had toward me, saying that, oh, I'm only doing this. I'm only this way because I'm being protected by the bench. That's absolutely not. I'm the same way 24 hours a day. Okay? So let's get that straight. This robe has nothing to do with me as a man.
What you just watched is a perfect example of how courtroom dynamics can completely shift based on behavior, preparation, and timing. And there's a lot to unpack here. Let's start with the defendant's strategy, because from the very beginning, he takes a confrontational approach. He challenges jurisdiction repeatedly, refuses to follow standard procedure like filing motions properly, and even attempts to assert authority over the court itself. Now, here's the legal reality. Challenging jurisdiction is absolutely a valid legal argument, but it has to be done correctly. That means written motions, proper citations, and structured arguments. What we're seeing here instead is a verbal, almost defiant approach, which the judge quickly shuts down. And you can actually see the turning point early on. The judge makes it clear, I'm running this show. That line right there sets the tone. From that moment forward, this isn't just about the case. It becomes about courtroom control. The judge is asserting authority, while the defendant continues to push boundaries, interrupt, and escalate. Now let me ask you this. Do you think this approach ever works in a real courtroom setting? Or does it almost always backfire? Then we move into another key moment, the discussion about trial options. The defendant believes he has the right to choose between a bench trial and a jury trial. But the judge firmly disagrees and redirects the process. This is where things get interesting legally, because while defendants do have rights regarding trial type, those rights aren't always exercised the way people think. There are procedural rules, and the judge has discretion in how the case proceeds within those rules. So again, we're seeing a misunderstanding, or at least a misapplication, of legal principles by the defendant. But here's where everything flips. Despite all the tension, all the back and forth, all the challenges and interruptions, the case gets dismissed. Not because of the arguments, not because of jurisdiction, but because the officers, the key witnesses, fail to appear in court. And that's huge. In criminal proceedings, if the prosecution can't present its witnesses, the case often can't move forward. No witnesses means no testimony. No testimony means no evidence being presented in court that day. And in this situation, the judge makes the call to dismiss. So think about that for a second. The defendant spends the entire hearing fighting the court, challenging authority, and pushing a strategy that doesn't seem to gain traction. And yet, in the end, he still walks away with a dismissal. Not because of what he argued, but because of what the prosecution failed to do. And that raises a powerful question. Was this a win because of strategy or just pure circumstance? Now, one more thing worth pointing out. The defendant immediately asks for costs and fees after the dismissal. That's a bold move. In some cases, defendants can recover certain costs, but it's not automatic, and the judge clearly shuts that down quickly. The hearing ends abruptly, almost on a note of frustration, but the outcome is already decided. So overall, what are the key takeaways here? First, courtroom behavior matters. A lot. Respecting procedure and presenting arguments correctly can make or break your case. Second, legal knowledge without proper execution doesn't carry much weight in front of a judge. And third, sometimes outcomes hinge on factors completely outside the arguments being made, like witness availability. Now we want to hear from you. Who do you think really won here? Was it the defendant for getting the case dismissed? Or did his approach actually hurt him despite the outcome? And if you were in his position, would you have handled this differently? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.